On May 18th, the Supreme Court of the United States delivered a much-anticipated judgment on the case of Twitter versus Thumbnail. This case was about the potential liability of the three major tech companies, Google, Facebook, and Twitter, for the terrorist attack on the Reyna nightclub in Istanbul, Turkey, committed by ISIS in 2017. The family of Thumbnail argued that by not detecting and removing a number of ISIS-related posts, accounts, and recruiting videos, the platforms could be held liable under the Justice Against Sponsor of Terrorism Act. The court dismissed the claims based on Section 230 of the Communications Decency Act, which generally provides immunity for online computer services with respect to third-party content generated by its users. The line between content moderation and censorship is increasingly blurry, but it is essential that big platforms can be held liable for illicit content shared by their users. Apart from their policies, it is necessary that the tech giants abide by international standards when it comes to content moderation. Platforms should be transparent about enforcing the policies, for example, by providing detailed explanations about the removal of content. However, leaving it entirely to the private initiative to regulate the issue can prove very dangerous. The US legislation obliges platforms to remove only certain unlawful content, such as child abuse imagery, but falls short in regulating other subjects, for example, hate speech. On the contrary, the EU adopted the Digital Services Act to tackle this problem by introducing clear liability of platforms for illicit content posted by their users. The ideal, however, would be to strike a balance so that platforms are neither completely free to impose their own rules nor subject to strict legislation that would create obstacles to their functions. The Supreme Court's judgment in the case of Thumbnail protects big tech companies from a potential host of lawsuits, and in this way contributes to users' freedom of expression online, especially in the Swana region. However, by dismissing the case, the Supreme Court missed an opportunity to set a precedent for holding tech companies liable for targeted ads or recommendations. This means that it's completely up to the platforms to decide what is and what isn't permitted online. Throughout the years, we have seen a bias towards certain communities, both in the Swana region and elsewhere, and therefore there have been cases of both over-moderation, for example in the Palestine context with the Meta's ban of the word Shahid, as well as cases of under-moderation, as it happened in Myanmar. It is therefore crucial that there are safeguards to limit the unlimited power of both tech companies and governments.